Hi everyone, bonjour. I'm Angèle Benard, National Director of Family Services here at the HSC. It is my honor today to introduce Judith Wahl in her session to attendees that are joining us in our first virtual conference. Judith is a lawyer now practicing as a legal consultant and speaker under the name Wahl Elder Law. She previously was the executive director and senior lawyer at the Advocacy Centre for the Elderly, a specialty community legal clinic serving all of Ontario for 35 years, and also practiced in a private law firm in Toronto for 6 years. Throughout her legal career, Judith has been very active in advocating for the rights of older adults and in the development of elder law as an area of practice. She was awarded the Queen Elizabeth II Diamond Jubilee Medal for her contribution to the development of elder law in Canada. She's also the recipient of the Osgood Gold Key Award for Public Service and the Ontario Bar Association Award for Distinguished Service. Today, Judith will discuss medical assistance in dying. And now, Judith, the floor is yours.
Thank you. Thank you. So I'm just going to pull up my slides. Okay, so I'll just before I begin getting into the content, I just want to tell you I'm going to be going fairly quickly through the part on MAID because I want to do enough time on talking about the advance consent, but I need to set the scene by talking about MAID first. And also, since MAID was changed just this past week, I want to give you the update on what the law is now. Also, I have to do this disclaimer since I'm a lawyer. This is legal information, but not legal advice. If you need legal advice, please consult your own lawyer. Okay, so what I'm going to do today is I'm going to go through MAID and as it is after March the 17th, 2021, because that's when the federal government changed the legislation. So we'll talk about particularly about eligibility, the process, its availability and limitations. And I want to go through that so that you see the context for the discussion on advance consent. And then we'll get into what is advance consent or advance request to MAID. What is that? How does it relate to how health decision-making works in Ontario now? And then talks about the pros and cons. I'm going to try to give you a very neutral approach to this so that you can see the arguments in both directions. So just getting into MAID. One other thing I should say ahead of time, all these slides are available for downloading for you, so after the fact. So if I've skipped some of the slides because of timing, because I want to make sure we have enough time to have discussion, you'll be able to see all the details. So just getting into where did MAID start from? So it was a decision of the Supreme Court of Canada in February of 2015, and that court decision struck down the ban on assisted suicide in the context of physician-assisted death. So our criminal code had a provision that nobody could assist somebody to die, and that it was a crime for a health practitioner to engage to cause somebody's death in this way. And so the Supreme Court said that the Quebec law, which actually had already been enacted, could stand. And they have a slightly different legal model because they have the civil code instead of the common law, and gave the government time to then develop the legislation to make the necessary amendments to the criminal code so medical assistance in dying could be permitted. So the Carter decision actually voided 2 sections in the Act, but only in respect to medical assistance in dying. So somebody could still be guilty of these offenses about causing somebody's death in this way. The federal law came out in 2016, and then it was just amended last week. So I was madly doing changes to my PowerPoint. So now it's important for health practitioners to comply with the criminal code as amended. And this is a very strict compliance kind of legislation. Because it's causing the death of a person, albeit with their consent, the procedure has to be followed as set out in the legislation. And as well, it's the eligibility is very important. And I'm going to go through the eligibility. So the legislation, even as amended, still doesn't directly follow the Carter decision, but it does permit MAID, and the recent amendments from last week have brought it closer to what the court actually decided. The government was not bound to follow strictly the court decision. They could implement MAID legislation that was substantially like what was in the court decision. So certain issues were not addressed in the MAID legislation. So one of these is the advance request for MAID. The other one is request by mature minors for MAID. And the third is where mental illness is the sole underlying medical condition. So these are not in effect at this time, but the new amendments did say that within 2 years, there's a 2-year time limit, the federal government does have to implement MAID for people who have mental illness as the sole underlying medical condition. So over the next 2 years, they've got to do a lot of work to figuring out how could this be done in practice, because there was a lot of concern of how you implement it. And it's if you're interested in advance requests, you should follow the discussions about how to implement the mental illness as the sole underlying medical condition, because a lot of the same issues come up of how do you implement this kind of thing. It's very difficult. So the changes to MAID that came in last week, Bill C-7, they had a bill a year ago, the same thing. They reintroduced it when Parliament came back into session, because all bills end when they leave for a term. And so now the criminal code has been amended to allow MAID for people who wish to pursue a medically assisted death, whether or not their natural death is reasonably foreseeable. The requirement that of eligibility at natural death be reasonably foreseeable has been struck out of the legislation. And this is, again, to follow a case that happened in Quebec. You can see how law develops, cases come to the courts, and then a decision is made, because even when you're drafting legislation, it's hard to know how to make it practical. And you don't know all the variations on a theme. So that's why the court cases are very helpful in underlying that. So what actually is MAID? So MAID is the administration by a medical practitioner or nurse practitioner of a substance to a person at their request that causes their death, or it's providing that medication to the person so that they can self-medicate and therefore cause their death. It's very important, it's at their own request. So this has been the barrier to advance requests, because it's at their own request at the time that the death is going to occur. It's not called suicide to avoid problems with insurance, and people did not find that a comfortable clause. If we're going to give the medical assistance in dying, we didn't want to have it stigmatized by calling it suicide. And it can be clinician administered or self-administered. The criminal code sections still exist in that were changed for the purposes of MAID, still exist. And MAID is an exception to these offenses. So that's why you have the health practitioners have to follow the code very strictly. And the criminal code also states that certain health professionals, and I've listed them all on the PowerPoint, they don't commit an offense if they provide information to a person about the lawful provision of MAID. So that's not considering counseling a person for death. So people have to request MAID, and then they can get the information without any barrier. Now, let's get into the criteria. You can only receive medical assistance in dying only if people meet all 6 criteria. And so the first one, you have to be covered by public health insurance. So they did this so that we wouldn't be a vacation site, so people would come here to have a death. That's in effect what Switzerland has allowed. Switzerland will allow you to go there to have a physician-assisted death. But Canada didn't want to provide that to others outside of Canada. So you have to be resident in Canada receiving OHIP, or in Ontario. You have to be at least 18 years of age. So it's an age criteria. And mental capacity, you have to be mentally capable. So again, this is one of the issues, is about, could mature minors, so kids that are 14 to 18, which are usually the mature minor ages, could they request MAID if they had the health conditions that would meet the other criteria? So that's not being allowed. So this eligibility is a bit different than healthcare consent. So for any other kind of health treatment in Ontario, or any kind of health care, there actually is no bottom age to be able to consent. So children can actually consent to their own health care if they are mentally capable. But MAID is limited to people 18 and over. What's capacity to consent to MAID? Basically, you have to be able to understand and appreciate the certainty of death upon receiving the MAID medication. So all the definitions of capacity are talking about the ability to understand and ability to appreciate. So it doesn't mean that you can talk through it. You don't have to be able to communicate in that way. It's as long as somebody can figure out if you're able to understand and able to appreciate the certainty of death. The capacity, the person consenting to MAID must be capable to give informed consent to MAID both at the time of the request for MAID and at the time MAID is administered, unless special circumstances apply. So one of the amendments that was made is that you can arrange for a waiver of the final consent. And this is actually a limited form of advance consent, but it's very limited. The waiting period normally is 10 days, but that between asking for MAID and being found eligible and then when it's delivered, but that can be shortened with the agreement of the health practitioners if they think that you may not be capable at the time that within that period of 10 days. And so the law still says that there has to be the players deciding that whether it's appropriate to shorten the waiting period of time. Now, you can do a waiver of consent at the time MAID is administered. You can waive the requirement for giving final consent just before MAID is provided only if your natural death is reasonably foreseeable. So it's not for those people whose death is not reasonably foreseeable who are now eligible for MAID. And while you had decision-making capacity, you were found eligible to receive MAID. Your practitioner told you at that time that you might lose your capacity to provide the final consent, and then you make a written arrangement with your practitioner in which you consent in advance to receive MAID. So you have to do a document in writing. We don't know what that looks like yet because we don't have what is called the regulations that talk about the process. But but there has to be this written agreement in advance. You have to make this arrangement with your practitioner so that they can administer MAID to you in a specific situation. This allows for practitioner-administered MAID in the event of complications with self-administration that cause your loss of decision-making capacity, but not your death. This was a concern by people who were doing MAID by self-administration. But then your practitioner has to be present at the time you are self-administering the medication. The reason that they required the capacity at the time, just before your death, is that people have to have the right to rescind the request right up to the last moment. This is a final decision, and so they wanted to make sure people had the ability to opt out at any time, so that protects their independence. Who assesses capacity for MAID? It's going to be whoever's the practitioners, the medical practitioner or the nurse practitioner who's administering MAID, as well as the medical practitioner or nurse practitioner that provide the second written opinion. There must be at least two opinions the person's capable to consent. There's no substitute consent. So those of you who know the health decision-making system in Ontario, you'll know that if you yourself are not capable at some point in time, then you can choose a substitute decision maker to act for you in the future by preparing a power of attorney for personal care. Or if you haven't chosen in advance, there is a list of family members and others that are in the Healthcare Consent Act that can make the decision for you automatically without either your family member or you having to do anything. So the higher levels, if the court decides something, you have a guardian, the guardian make the decision. If you pick somebody, then it's your attorney in a power of attorney. Somebody could also apply to the Consent and Capacity Board to make the decision for you. And then it's a whole list of family members. And they get the right in that order that's set out in the law. But this doesn't apply to MAID. Substitute decision makers have no decision-making role in MAID. They didn't want to do that because of the possibility of conflict, of influence, and it's really to avoid abuse. And so this is the list that's in the Ontario legislation in the order that people can make the decision for you. And it's whoever's highest in your life on this list that can make the decision for you. There's no advance consent or advance request for MAID presently in the legislation, although it's being studied. And when not yet eligible for MAID, you can't ask that MAID be administered when you reach an advanced state of mental incapacity. Even if you have a health problem that is likely that you will become incapable and meet other MAID conditions, you also can't do an advance consent for that. The fourth element of eligibility for the fourth of the six, you have to have a grievous and irremediable medical condition. So what does this mean? So they define it in the legislation. You have to meet 4 criteria to have a grievous and irremediable medical condition. You have to have either a serious and incurable illness, disease, or disability. You have to be in an advanced state of decline. So it's not at the beginning of having this illness. You will have to go through a period of the illness and be on that decline level before you would be eligible. And that your illness, disease, or disability is causing you enduring physical or psychological suffering that is intolerable to you and cannot be relieved under any conditions that they consider acceptable. So it's very individual based. So it's you that has to find it intolerable, not somebody else judging that it's intolerable to you. And you could reject some of the means of relieving the pain or the suffering, and choose not to accept some of that assistance because you don't feel that it's appropriate for you. And so then this section about the natural death has been repealed. So mental illness is a sole medical condition. People with that as a ground for MAID will not be eligible for MAID until March 17th, 2023. And this period is being delayed to have this because the government needs more time to consider how MAID can be safely provided to those with only medical condition as mental illness. There's a lot of interesting submissions that were done to the government on this point from all kinds of people, and I can tell you it's people with mental illness as much as many psychiatrists were objecting to this as a ground for MAID, and then equally you saw people who were supporting this who were also from those same communities. And so the government's going to be creating an expert review to consider the protocols, and I would expect that they will do public consultation on this as well. The fifth criteria is that you have to do a voluntary request for medical assistance in dying. And this has to be made without any external pressure. And it's up to the health practitioner that's that's going to be giving you the medical assistance in dying to determine whether you did it voluntarily. Because there was always a big concern that people could be persuaded to consent to MAID when they really didn't want it. And I know when MAID first came in, I had a couple cases when I was working at ACE where people were being offered MAID as an option when they weren't getting sufficient home care. That is not supposed to be a reason for telling people about MAID and telling them that MAID is the option. We should be getting the appropriate home care to people so that they won't have to consider that. It's the same thing with palliative care. Palliative care should be universally available so people don't have to look to MAID to relieve their suffering when they can't access, just because they can't access palliative care. The sixth ground for MAID is you must give informed consent to receive MAID after you're informed of the means that are available to you to relieve your suffering, including palliative care. So the eligibility and informed consent, you really have to understand your health condition. It's interesting, I've looked at research. A lot of people actually don't understand their health condition and don't understand their treatment options. I'm doing a lot of work on this now, and it's shocking to me that people really don't get that information and their health practitioners don't explain it to them in enough details that they can fully understand it. They also have to understand the option for treatment of their condition. So again, you have to be told what are the various options, not just the ones the doctor recommends, but the other options that could relieve your suffering. And you have to be informed, understand of the means that are available to relieve your suffering. So that's the sort of the system for MAID, but there are a number of safeguards that are included in the criminal code. So before the medical practitioner or nurse practitioner deliver the MAID, they have to ensure there's compliance with the safeguards. And this, again, it's very strict compliance. So the safeguards that apply to all eligible persons, whether or not death is imminent, you have to undergo medical assessments. You have to submit a signed written request for MAID. You have to be informed that you can withdraw your request for MAID at any time and in any manner. It's interesting, there have been some studies to show that even after people are assessed as being eligible for MAID, and particularly people who are going to self-administer, they don't use the drugs, and they just want the assurance that they can do it and have MAID if they need to from their own opinion. And the final consent, you must be given the opportunity to withdraw consent to receive MAID, subject to the waiver of this final consent. Now, so they've split now with the new law to people where death is reasonably foreseeable and where death is not reasonably foreseeable. So if death is not reasonably foreseeable, there's other criteria, other safeguards that have to be met. So one of the two health practitioners who provides your assessment, they have to be experts within the area. And if they don't have that expertise, then they have to consult with somebody to get that expertise. So it's not going to be somebody who's going to be dying before they have to, because they will have all the information from the person who really understands the disease, the disorder. You have to be informed of available and appropriate means to relieve your suffering, including all those different kind of services, and you must be offered consultations with those professionals who provide those services. You or your practitioners must have discussed reasonable and available means to relieve your suffering, and all agree you've seriously considered all those means. You can see they're really trying to get people to really look at this in even a farther depth. And your eligibility assessment must take a minimum of 90 days unless the assessments have been completed sooner and you are at immediate risk of losing your capacity to consent. And then you are given the opportunity to withdraw. So, should MAID be permitted with advance consent on advance requests? This is an ongoing debate, and I'm not going to tell you whether I'm for or against. I really want to give you a neutral approach. But what I have been frustrated with a lot of the discussions on this, because people think it's simple, but it's a much more complicated issue than what I've seen. So when they've done, when I've seen these surveys about whether you want to have advance consent for MAID and whether the government should do that, that's a very simplistic question, because it's not being fair to people to understand what this really means. And I do refer you to this document, and I've given the reference to it again later in the thing. This document that was prepared by the expert panel working group on advance requests for MAID. It's an excellent document. It doesn't make a recommendation to the government, as all those reports. There was a report done on minors, on mental health, and then this one on advanced consent. And this is a really good starting point. So it really explained what the law was and the various difficulties in creating advanced consent. Right now in Canada, there's no clinical or legal standing in Canada for this type of concept, as all healthcare in Canada requires an informed consent. This has been the law since 1970. So the working group that wrote that report defined advance requests as a request for MAID created in advance of loss of decision-making capacity, intended to be acted upon under the circumstances outlined in the request after the person has lost decisional capacity. So they didn't include in the definition whether you had to already have know that you have a certain kind of disorder that could lead to suffering in the future. So it's really just in advance you're going to give consent. Can't we give advance consent now to future treatment? I'm often asked that, because people think, oh yeah, I can do these living wills, advance directives, and I can give advance consent. Well, none of those are advance consent. And actually, I'm really I keep on telling people not to even use that language. It's the legislation talks about the ability to give wishes in advance about what you would like for health care in the future. But there's not no provinces across Canada give a blank advance consent process. There's real big variations across Canada about how does advanced care planning work, where you can express your wishes about future care and have it implemented, hopefully by your substitute or whoever is your decision maker. But there are big variations across the country and a lot of misunderstandings about it. So right now you can't provide advance consent. So right now, under the law, if you become incapable to consent for your own health care, then the Ontario law provides for a system of substitute decision-making. Your substitute must then step in to give or refuse the informed consent on your behalf. When you are capable, you can express wishes, and I emphasize the wishes about your future health care in writing, or orally or by alternative means. So you can do it in writing, you can write something down, or you could just say it to your future substitute or anybody else. Or if you use any kind of assisted devices to communicate, you can communicate through the alternative means, those assisted devices. So these wishes are not decisions, but are wishes, because you don't have all the information to give an informed consent. So you're speculating. And what people speculate is not always what they show that they don't really understand their health condition. So your substitute is required to follow your wishes when making health decisions for you, unless a wish is impossible to honor. So common one that I saw that was impossible to honor, people would say, I never want to live in a long-term care home. And that's not a criticism of long-term care homes. It's just some people never want to live in a long-term care home. But that may be impossible to honor unless you've got a lot of people in your family that are willing to provide you with the care and support, or you have a lot of money so that you could purchase care, so that you don't have to enter into a group facility. Or the other situation where your substitute doesn't have to follow the wish is if your substitute believes that you would not have expressed that wish if you knew what your options were now then not instead of at the time that you express your wish, then your substitute can go to the Consent and Capacity Board and make the argument for an order to not follow the wish. So an example of this would be changes in how health treatment is delivered. So in some cases, people would object to having an operation, but they would not object to surgery being done through a laparoscopic method. So they don't want to be cut open, but they don't mind if you have laparoscopic surgery. I had laparoscopic surgery. I had 11 holes in my body, and they put all the tools into the holes to then look inside my body and do the operation. It's amazing. You heal up very quickly. And your substitutes have to determine if your wish is your last known capable wish, whether it applies, and what you meant by that wish. So your substitute interprets what you mean. If your substitute believes that your wishes don't apply or that you've not expressed any wishes relevant to the decision to be made, then your substitute must act what's in your best interest. So that's the healthcare consent method. So this is the information you're supposed to get to give an informed consent. And I'm mentioning this here only to make you think about, so what would you need if you're going to permit people to have advance requests? Because you would have to give the same kind of information to them, or some of the same kind of information about to ensure that the person understands their conditions and alternative courses of action. Consent also in Ontario always comes from a person, not a piece of paper. So even if you've written down, even if you've tattooed on your body, I don't want resuscitation, that can't be seen as a consent. They still have to turn to your substitute decision maker if you're incapable to get the consent. And that may be an expression of exactly what your wish is, and your substitute would follow it. But that's not enough. They have to get to the substitute. Treatment taking place in the future is not necessarily an advanced care plan. So by our present law, you can give informed consent to a treatment that is going to take place in the future, but relates to your present health condition. So as an example, my mom died 2 years ago, but when she was 95 when she died, so she was quite an advanced age. And during the last couple of years of her life, she was extremely frail. She did not want resuscitation. She was not a good candidate for resuscitation, but she actually could consent to no CPR to that because it was in the context of her present health condition. And this is not considered to be advanced care planning. It's considered to be consent. And those of you who know about the DNR confirmation form, that's also not an advanced consent to no CPR. It's not an informed consent in itself of itself. It's the confirmation form was created to enable health practitioners to communicate with emergency responders when patients have provided informed consent to no CPR and they're eligible to have no CPR. So because ambulance people emergency responders are not regulated health professionals, they have to get direction from a regulated health professional to not resuscitate you. Otherwise, they do have to resuscitate you. So that's the purpose of the DNR form. But in and of itself, it can't be relied on as an informed consent to no CPR once the person gets into the hospital. They have to revisit that issue because now the person's gone to hospital seeking care. So would they change their mind? So consent is not just a decision, it's a process. It's a discussion of the person's illness and the risks, benefits, side effects of treatment options, the alternatives. Right now in Ontario, there are a tremendous number of misunderstandings about informed consent. And I've seen this. I was involved in a research study that for the Law Commission, and I've given you references to that report, where we looked at, there were 3 of us who did the research, and 3 of us looked at 100 sets of documents and forms that are used in health facilities across Ontario in respect to informed consent. And none of them were completely accurate in respect to informed consent. I hope you find that shocking, but that's how misunderstood consent is. And again, this is something to keep into context when we're talking about advanced consent to MAID. So I see long-term care homes are still using levels of care forms and other documents that are totally improper. And although I've gone to the Ministry of Health numerous times to try to get these documents pulled out of long-term care homes without success, I'm hoping now, because of what's happened with COVID, we're going to pay a lot more attention to this. I even looked at some of the forms used for consent to the COVID vaccinations, and there's legal errors on a couple of them that I saw. They've got the wrong SDNs, and they also, some of the consents, and there's different consents all over the province, they are set up with patients confirming that they've read all the material on the COVID vaccinations and they're informed. But it's the obligation of the health practitioner to inform you. So a lot of people thought when they're getting their vaccinations, they couldn't ask questions. And that's not the case. So even in the government documents of this last couple months, they've misstated what healthcare consent is. So looking at the difference between advanced care planning and advanced requests for MAID, advanced requests for MAID are only in respect to death, so it's a final decision. So that's different than advanced care planning, because advanced care planning, as we know it now in Ontario, it outlines the preferences of a person that guides the substitute. But the substitute has the opportunity to reconsider the patient's present condition and options and put the speculative wishes in context. So there's a second eye looking at this. And that's very important because people change their minds. And also what they say, like I had clients would say to me, I want you to give me a document that says I don't want to have resuscitation ever. And then I would ask, well, if you arrested in front of me right now, would you want me to resuscitate you? And 99% of the time they'd say, oh, of course, because I'm not ill yet. And I says, well, you can't say you don't want resuscitation under any circumstances. There are some circumstances you would want it. So let's talk about that. So that's why you got to really go dig down into these things when you're talking about even with the wishes. So what would have to be done to have advanced requests for MAID? So I'm going to give you the next couple of slides. I'm just going to give you some of the arguments that have been posed. So it's been argued that you would have to change more in the law than just the MAID legislation, because provincial law governs informed consent in health care. So just as I described you what the Ontario system is, it's different than in British Columbia, in Alberta, in Nova Scotia. So all the provinces have created different schemes. Could you ever get them to be agreeing? I would doubt it. And I don't think you can really do this effectively, have advanced requests for MAID, unless you looked at that, because otherwise there's going to be confusion about what's consent. The advanced consent request for MAID, I think, would require a regulatory framework that involves both provincial, territorial regulation and the federal law. Now, some people disagree with it. That they say, oh, no, we can just have it just for MAID. I have a difficulty figuring out how that could be done. And I can tell you, I am a bit of an expert on healthcare decision making, because I've been working on it since 1984. Since I started working at ACE, I was involved in all the committees that created the legislation in Ontario. So I've had the opportunity to really learn a lot about healthcare consent. But if you are creating advanced requests for MAID, how do you determine capacity? How do you determine the influence at the time, because the person's not yet suffering? So how are they going to judge that they will be suffering in the future? What information would be needed to determine if informed consent is being given? I see people not saying all kinds of wishes about their future care, but when they actually have a certain condition or their health declines, they completely change their minds. How do you determine voluntariness of the advance requests? It's not impossible, but I'm just saying we've got to get deeper into understanding how do you do this. So if you look at the capacity itself, so you have to be capable at the time you created that advanced consent, but do you understand your illness, and do you have an illness that could lead to suffering, terribly in the future? Or should the advance request be permitted to people that are speculating they might have some disorder in the future, but they've not yet had a diagnosis? I think a lot of the people debating this would say, no, they have to have an illness that potentially would lead to suffering. And that would make sense. If you're going to offer advance requests, we've got to narrow it to something like that. It has to be voluntary. The advance request is it still in effect at the time that MAID is being considered? It has not been changed. People change their minds all the time. If they're going to give advance consent, would you have to have safeguards like preparing these documents with health practitioners and lawyers, or just a health practitioner, or just a lawyer? So I've given you some more details. I'm just running out of time now, but I've given you more content about each of these points, about capacity. How do we determine it? How do we look at informed consent in advance? How do we talk about it? How do we explain things to people, particularly when health treatment changes over periods of time? Like Alzheimer's now is being treated differently than it was 30 years ago, and people are living longer before it advances. So there's a lot of other disorders that are like that. What is the best way of dealing with the information? What information would have to be given? Voluntariness would you have to have the same health practitioner that works with you to get the advanced consent, as well as the same person would have to administer MAID for you? So how do you do that? Because often people want to give advanced consent it could be years before they're giving the advanced consent, before they're really in the full stage of the suffering and meet the conditions they've set out when they would want MAID to be implemented. How would you know the advanced request is still in effect? How would the health practitioner determine if conditions on which consent are based now are in effect and being experienced by the patient that gave the advanced consent? What if some of the conditions are met and not all? So the example that's often given to this is, again, I'll use Alzheimer's because it's easier to talk about that, is the person could think that they don't want to, they want MAID if they can't recognize their family. But that can happen very early, and they could be very happy still living with the Alzheimer's, and they don't seem to be suffering. So would the health practitioner administering MAID interpret the conditions in the same way as the patient wanted? Who would determine if the advance request for MAID is valid? Could we get substitute decision makers in there? I don't think substitute decision makers will play any role in this type of thing because of the fear of abuse with that. And then other safeguards. Think of all the other different safeguards that you would need. And how many meetings would you have to have, and with whom? Would there be time limits on the validity of the advance request? And costs. This is not, there's no cost to anybody in respect to MAID right now. But if we have advance requests, would it be fair to charge the health system with the cost of all these meetings and discussions when the person is not yet in a state of suffering? And would it be fair for the health system to bear the costs? So I'm going to stop there. I've given you some resources on advanced requests for MAID and resources on more information on MAID and also on healthcare consent. And I've also left you my contact information if you want to engage in any further discussions in the future with me on this. And so now I'm going to turn it back to Angel so that we could do questions.
Thank you, Judith. We've got a couple of questions that have been coming in as the presentation was going on, but I'd encourage folks, if you have more questions, feel free to add them to the chat, and I will share them with Judith as we have time, as time permits, I should say. So the first question was from Mariana, and she was asking if this is the representation agreement in BC is the exception.
Is the
representation agreement in BC the exception?
Well, it's not an exception. That the representation agreement is as we have substitute decision making, British Columbia has representation agreements. And then they have another thing with substitute decision. They do have some substitute decision makers in their law. Their law is actually a couple levels. So with the representation agreement, their intent of that was try to not take decision-making authority away from the person. But if the person does become incapable, that really can't engage, their representative is going to be making the decision. Even if somebody is going to tell me that the representation agreement doesn't do that. But it's somebody you trust that's going to be helping you make the decision. So it's still requiring consent. It's still a consent process. It's just the variant. There's all kinds of things. Like in Saskatchewan, they have, I forget now, well, there's supportive decision making. There's some other thing. There's something else in Saskatchewan. Saskatchewan's got like 3 different levels of things. So it's complicated. But these things, if you're going to have advanced consents for MAID, I think you have to look at all of these together, all these different nodes together. And I think people have misstated the representation agreements as being part of advanced consent.
Okay, thank you. Joe has a comment. A number of medical articles written in the US have indicated that antidepressants and antipsychotics may exacerbate our loved one's condition. Is this being considered? And I believe it should be better reviewed and researched.
In terms of their decision-making authority, ability, and capacity, I'm going to assume that. Yes, and that is something that's important. I would. For the health practitioners that are involved in looking at consent, they need to look at that individual. What is the kind of disorder they have? What kinds of health problems they have? And consider that in determining capacity. No question, because it shouldn't be that somebody's found incapable just because they're on some medication, whatever it is. So they really need to look at that individual and whether if they took them off that medication, would they have become capable again? Like, so you can't. It's like saying that if somebody's drunk, oh well, we're just going to talk to them and they can give consent. Well, you can't give consent when you're drunk. You can't give consent if the drugs affect your decision-making ability. So the health practitioners who are doing MAID, I think, definitely do take that into consideration now and are looking at, they got the expertise to sort that out, or they should. And if they don't, it should be brought to their attention, and experts involved in the field of that particular disorder, that information be brought to the physicians.
Okay, thank you. Bev just added a comment that Dying with Dignity Canada has a lot of good resources for information on MAID. So they do have a website. You can check that out. Someone was asking if we could post the contact info again, but what I'll tell you is if you look on the right-hand side of the chat window, there's a tab called Files, and there's actually in that section, that's where you can find Judith's presentation, and her contact info is there. So you can download that and you'll have that as well.
I'm going to give you, to be very fair, like the Dying with Dignity, there's lots of stuff on their website, no question. And I think there's some really good stuff on there, but there's some stuff I wouldn't agree that complies with the law. And they do support the advance requests. So take that into consideration. That doesn't mean that you don't read the sites. In fact, I think that's important to read the stuff that they're presenting and their arguments, because it gives you more of that argument on that side. But then I also suggest looking at other literature. Like I know there's a professor who I absolutely love at U of T. He's a law professor named Trudeau Lemons, and I'll spell it because I can't write it out for you. It's Trudo, and Lemons is Lemmons. And he has certainly written on this issue, and he has been looking at medical assistance in dying in depth. Like he's done all the research in all the countries in Europe that have provided with, and I find he can present a very good unbiased argument, and I think he would oppose the advanced consents, but he does do the research, and you can see some of his arguments both ways. I've read articles where he's giving the problems both ways of whether you have advanced consent or you don't have advanced consent.
Okay, thank you. We have another comment from Dr. Mark Gutman. The new provision from last week requires that the MAID providers are familiar with the condition. So it's been my experience that many providers do not know about HD and have not been good judges of the severity of the condition. So if experts are going to be required, it may be a good idea for the HSC to assist by developing a list of regional experts to provide this assessment.
And that's a very good comment, because it's where death is not imminent. Like, so that criteria that they've removed, so and that's what's one of the safeguards that I pointed out, that there has to be the expertise by one of the people involved in delivering the MAID, or they have to seek it out, and that's very important. It's because they want to make sure that everybody's protected, so it makes sense. They know it from all directions.
Okay. And then the last comment, I think there's a lot of great feedback that the information is very much appreciated. And so someone is mentioning we need to stop the rule making and be more practical. So I'm thinking of a recent that could not utilize MAID. So I guess in the community, people have had both successes and challenges in accessing MAID.
And and that's you're making an excellent point. So that's why I put on the slides the kinds of things to think about, because that's why I find that when people talk about advanced consent or advanced requests, they just think of it, oh, I can do it. It's really easy. Look at all the things I've written down in those slides and what would have to be done to make this happen, because you're looking at how do you make it practical. So the same thing with the mental health. They've got 2 years to figure out how do you make this work. So it's the same thing. If people want to support advanced consents, they've got to look at it in greater depth than just doing a survey. And because if it's wanted, you got to look at all the ramifications of it and the steps that would have to be taken, and to be practical, because that's what's necessary. It was just like the change that was made to the legislation last week that said there has to be expertise if your death is not imminent. Makes perfect sense.
Okay, great. Well, Judith, on behalf of the organizers and the attendees of our HSC conference, I want to thank you for your caring and thoughtful discussion on this topic. We greatly appreciate your knowledge and your insight. And remember, as I mentioned earlier, folks, that Judith's presentation is available in the Files tab on the right, should you like to download it. And so I think it is now time to check into your next session. So I just want to end by, again, thanking Judith very much for spending this time with us today.
And thank you for having me here, and thank you to everyone who attended the session. And I gave my contact information deliberately so that I am going to be writing on a lot of these issues now that I'm semi-retired. So if you're really driven on some of these points, feel free to contact me, because I would welcome it. I'd welcome your feedback. Thank you.
Sounds good. Thank you.